Ladies and gentlemen, that concludes the evidence in this case. I believe it's quite reasonable that we will be in a position to give you jury instructions at 1 o'clock or shortly thereafter, and that then the attorneys will be given an opportunity to make their summations to you. And it's my expectation that this case will be yours for deliberation probably late this afternoon. We have a few matters that have to be dealt with prior to instructing you. So I am going to give you folks a somewhat longer lunch today than usual. And we will resume at about 1 o'clock. And I will apologize in advance if we're just a little later than that, but I ask that you be here at 1 o'clock. So if things do go as I think they will, we'll be ready to start at that time. I want to emphasize again the importance of the admonition that I've given to you previously. You are still bound by that admonition, and there can be no discussion about any of these matters among yourselves or with anyone else until you are finally have been instructed, the attorneys have made their final arguments to you, and that you are in the jury room for deliberation. And that just remind you of the other section of that, the other part of that, about not doing any independent investigation of any kind because of the importance of all evidence being, the case being decided by the evidence presented. And with that, unless there's any questions someone has, we'll see you at 1 o'clock. We are now convened outside the presence of the jury. Mr. Kendall, do you have any motions that you would like to make at this time now that all parties have rested?
Yes, Your Honor. We renew the motion that I previously made. I assert the same grounds, specifically as to the elements of the offense and on the same arguments that I made previously.
Okay, just so for my understanding, I want to make sure I have a clear understanding of your motion. If you can't do something. As I understand, your position is that the elements of the state has not proved that the act has not been justified beyond reasonable doubt.
Correct.
Secondly, that the state has not proved malice of forethought beyond reasonable doubt.
Correct.
Thirdly, that the state has not proved deliberation and premedication beyond reasonable doubt.
Correct, sir.
It was premeditated.
That would be correct.
Okay, are those the three?
Those are the only grounds that I'm raising in my motion.
Okay. Is there anything the state would address on those matters at this time?
No, the state's reason would be the same that stated yesterday. The state would resist the defendant's motion for judgment as well.
Based on the evidence that's been presented in the case, the court believes there is sufficient evidence from which the jury could find beyond reasonable doubt each of those elements, and accordingly the motion for directed verdict will be overruled. Are you gentlemen prepared to address the issue of jury instructions at this point in time? I think I've provided you with them. If not, more time, that's fine. We can take a little break. But,
Your Honor, if the court doesn't mind, I haven't had a chance. I know the court was kind enough to put them out here this morning, but I haven't had a chance to just go through them quickly. If we could have a 5-10 minute break.
I would request that as well, Your Honor.
no, that's fine. And if it takes a little longer than that, just let me know. And just when you gentlemen are ready to make that record, let me know.
Thank you.
He's handled some research on that.
Okay, with respect to you, Mr. Kendall, you alerted the court to that, and as I understand, you also alerted Mr. Hammerand
Yes.
to what you were going to request as an instruction. I think I would ask that you, the stock instruction has some choices that can be made as to what exactly you want to focus on with that instruction. And I would, rather than trying to guess what your concerns are and what the defendant would like to have, I would ask that you at least fill in those blanks a little bit so that I and Mr. Hammerand are really alerted as to what your thoughts are on that matter. And then we can address the matter of that requested instruction. If there are other issues in the instructions that you have some objection to, let's take those up now.
Thank you, Your Honor. The instructions 19 and 20 of the proposed instructions both address an inference of malice aforethought simply because an instrument was used in the commission of the crime. I think that those instructions should be removed entirely from the jury instructions. We reviewed the case State v. Ambrose, which was a January 2015 case, Your Honor, that discusses the malice aforethought and this particular set of jury instructions, the inference instructions, Your Honor. The jury could draw an inference under the circumstances here that isn't otherwise supported by the evidence, Your Honor. The malice aforethought instruction, element, not only addresses with regard to the using of the weapon, Your Honor, in this case, it's distinguishable from the cases creating the inference, in that the defendant did not bring the weapon to the altercation. There was no break in opportunity to get the weapon, or in other words, he did not get the weapon and bring it into the altercation. All the other cases that address this presumption, the defendant brought the weapon to the altercation, and not only that, but together with other evidence suggesting intent, premeditation, and malice. For instance, Your Honor, in State v. Blair, the defendant brought both a gun and a bat to a residence in violation of no contact order, proceeded to shoot the victim and another person in the house. In State v. Smith, the defendants were in the city intending to commit a burglary with a loaded weapon, and in both of those cases, the defendant brought the weapon into the altercation, thus causing the death. In this case, Your Honor, the weapon was brought into the altercation by the victim. And under the best evidence we have about how it went forward, the altercation, the weapon was just there and is no more a part of the altercation or no more a weapon here than the defendant's own hands. I think that using the instruction permitting an inference of malice aforethought, or presumption of malice aforethought, in this case is contrary to the law and also results in an improper comment on the evidence by the court and jury instructions. Thank you.
Are there any other instructions other than, I understand your objection to 19 and 20, and I understand that there's a request, a further requested instruction, but as to the other instructions, other than the requested one and 18 and 19, or 19 and 20, are there any other objections the defense has to the instructions?
No, Your Honor. There was a sentence in instruction 17 that would also go along with the record we just made, that has been removed from the set we received today.
So 17 is all right now?
Yes, Your Honor.
Okay. Mr. Hammerhand, would you to address the matter of instructions 19 and 20 at this point?
Yes, Your Honor. The state also had a chance to review the State v. Ambrose case, and that case, obviously, the facts are different than this case. However, this is a situation where both people lived in the house. So it's a different situation where it's not Mr. Green lived in town and came over to visit Mr. Costner. They both lived in the house, so it's not about somebody bringing a weapon to the house. They both were living there at the time. The way the defendant described what happened at the police department in March of 2014, the demonstration, is he knocked John or Mark Costner to the ground after hitting him in the head, then jumped on top of him with the baseball bat and put it on his throat and choked him out. That fact pattern is different than the hypothetical situation in Ambrose that was talking about somebody being on the ground, being pummeled, and using something to get the person off them. So the state believes in this case the inference instructions, number 19 at least, should be allowed with the definition of a dangerous weapon in instruction number 20. Thank you.
Yeah, Your Honor, the hypothetical situation that was published in Ambrose, written by Professor Rigg, I think is precisely the kind of danger that we're dealing with here in this case today, and precisely the kind of danger that the court is suggesting in the Ambrose case. By saying bringing a weapon to the altercation, I don't mean to the location, but the weapon was brought in not by Mr. Green, but by Mr. Costner. He created, or he provided the weapon in the altercation. And it's the concept of both the pre-planning of getting a weapon and bringing it into the altercation that is what creates the inference of malice aforethought, premeditation, and the element that we're addressing here. So the inference itself is presumed because of bringing the weapon into the altercation. That premeditation is what I believe, by reading the case law, is what creates the inference.
The objection to 19 and 20 is going to be overruled. It seems to me that the critical, and the facts here are not, can be looked at different ways. And it seems to me the critical question here is the opportunity to deliberate, and I guess the one thing I might I think, however, 19, as I look at it, may have the same issue that was kind of informally discussed before, and that is that may not be just the opportunity to deliberate, but also the actual deliberation. And I guess if anyone wants to address this, because I'm kind of bringing into this up, that it should actually, it seems to me that if there's a chance to an actual deliberation, and then the use of the dangerous weapon, that's a perfectly valid inference, but I will let everybody address that issue.
I think, Your Honor, I think that's adding something that's not required under the stock instruction. Obviously, if the person doesn't deliberate, they're not going to get to any of these. Just having that opportunity, and obviously, that's what the instruction says. So the state would, I guess, prefer how the instruction 19 is worded as is now, without adding any of the additional language that's not included in the statute.
Defense have anything else to say?
Well, Your Honor, it's sort of just along the lines of what Mr. Carlson said. I think when you read instruction 19, what they're saying is you have the opportunity to deliberate, and then it's the use of the weapon during that opportunity to deliberate. And what's inherently unfair in this situation is that under any circumstance, the defendant isn't the one that originally produced the weapon. And that's sort of like in Ambrose, because in Ambrose, he wasn't carrying a weapon, he wasn't armed, he hadn't pre-planned getting a weapon. You know, none of these thoughts and things had been in John Green's mind. With the evidence that's been presented in this case, there's nothing that says he was armed at the time that he was attacked. And so he became armed during the attack with the weapon that had been used to attack him. So I don't see how you can then necessarily get an inference. It seems to me inherently unfair then to say that you get to infer malice, deliberation, and all of these things when he's not the person that thought to bring the weapon to the fight.
I'm going to reserve this and look at it more closely. I'll read the cases if you're feeling that there's a difference between that. Take a look at it. Do you have, Mr. Kendall, a specific requested instruction?
Your Honor, how I would read that, how I would have that read is evidence has
Just
been,
a moment. Okay.
evidence has been received concerning Mark Koster's character for being violent in an effort to show that Mark Koster was a dangerous and violent person. This evidence, so new paragraph now, this evidence bears on whether Mark Koster was the aggressor at the time the defendant strangled him. And we would just leave out that last part because I don't think that evidence can be used for fear or anything under the current record. But it would be able to be used for that issue of whether he was the aggressor at the time.
Mr. Hammer?
Yes, Your Honor. The state does have concerns that the medical records were offered in to show that the victim has schizophrenia, and the state, I think, at the time was objecting to getting into the slapping of the 7-year-old because it has nothing to do with the schizophrenia. However, now the defense wants to bootstrap that in and say we're offering it as character evidence. So I guess the state's concerned that that incident can be used as a character trait when the state's understanding the medical records were being just offered to show that his diagnosis was schizophrenia. So that's the state's concern. But if the court thinks it's appropriate, that would be fine with the state as well.
Could I just respond to you?
Yes.
Dr. Conard did testify that there's 3 things that were predictors of an increased chance to be violent. One of those was not being on medication, being diagnosed with this illness and not being on medication. One was a prior history of violence, both of which are facts in this case. The reports demonstrate that he was diagnosed schizophrenia, had a prior instance of violence. So he is at an increased risk for violent episodes and behaviors, which we're not arguing general character, but first aggressor.
So I understand it. I understand, Mr. Campbell, the way you wish this instruction to read is evidence has been received concerning Mark Koster's character for being violent in an effort to show that Mark Koster was a dangerous and violent person.
I guess that probably isn't worded correctly, and that should probably say to show Mark Koster was the first, or was the aggressor, period. Because I think the other reading would be just general character.
Well, then the next sentence that you have is that this evidence bears on whether Mark Koster was the aggressor at the time the defendant strangled Mark Koster, right?
Yeah, I guess that's correct. I suppose we could, I mean, is the court saying you just put a period after?
Well, I'm not saying anything.
Okay.
I'm asking, it's a requested instruction, and I want to know what the request is so that I can.
Let's say it this way then. Evidence has been received concerning Mark Koster's character for being violent, period. This evidence bears on whether Mark Koster was the aggressor at the time the defendant strangled him.
With that request, Mr. Amaran, what is the state's position?
That would be fine, Your Honor. State has no objections.
Okay, then I will, let's see.
I think that could reasonably be put in under number 30, after number 33. It's in the same area as the other justification instructions then, and you have fewer to renumber them.
That would be fine with the state, Your Honor.
Okay, I need to take a little bit and review these cases.
You want us to wait in the courtroom, Your Honor?
No, you don't have to, because I'm not exactly sure how long it's going to take. Do the best I can. I'm not sure how long. As soon as I get them done, I would like to be able to, as soon as I make a decision, I would like to finish the record.
I can get a hold of you. Or does it come back, or how do you want to get a hold of us?
I'll tell you what, let's do it this way. Let's just be back here at a quarter to 1.
Okay, thank you.
Side of you will be I've come across yet.
I thought that's what we were doing the last hour. Okay. We are convened in the courtroom. Counsel are present. We're outside the presence of the jury. With respect to the two matters that were not previously addressed, all jury instructions were approved prior to the ruling. Other than those two matters, with respect to instructions 18 and 19, or 19 and 20 rather, the objections to those instructions is overruled. It does not seem to me, on the facts of this case, that those inferences or that inference would be improper. Regardless of the way the evidence is viewed, I think that would be appropriate. Those inferences could, but would not have, that inference could, but would not have to be made by the jury. But I do not think it would be improper if they made that inference. So the objections are overruled in that regard. With respect to the requested instruction, that has been included as instruction number 34, and all following instructions were, the numbers were changed on those. To reflect that added instruction. With respect to the typo that apparently exists in instruction number 10, the copies have been made of these instructions. I will simply tell them when I get there that that's a mistake, and that I will be getting them a substitute page so that that mistake is correct. Is there anything else that needs to be addressed at this point?
Not on behalf of the state, Your Honor.
No, Your Honor.
Okay, then how much, if any, time do you gentlemen wish before we get the jury back in here for your final arguments? And for the, so my reading of the instructions and your summations.
The state is ready, Your Honor.
It's fine, Your Honor.
Okay. Are you going to need any setup time, Mr. Hammerhead, at my conclusion of reading?
As long as the equipment doesn't malfunction, no, Your Honor. I believe it will be ready.
Okay, and I suspect, I don't know how long you're going to argue, or I don't know if you're going to be arguing to such an extent that you feel a break is going to be necessary.
No.
Okay. Mr. Kendall, are you going to want to break after Mr. Hammerhead is finished before you start?
Who's first?
I'm thinking that court reporter wise, are you reading the instructions first?
Yes. Let me tell you what I did. Okay. Yeah. I probably should have. My My intention would be to read down to instruction number 35, which is the verdict forms. And then, and at that point in time, to also read the verdict forms, and then to have the arguments, and after all arguments are completed, to read instructions 36 through 39.
I guess what I would say to your Honor is that just knowing how, human nature and whatnot, and if we go more than about an hour and 10, hour and 15 minutes between you reading the instructions and the initial close, I think we should have a break.
Well, that's what I was asking about. I mean, I don't, it's not fair to keep. And so we'll take a brief break in there, and I don't know if Mr. Hammer, I don't know how long that argument's going to be or anything at that point.
Okay, the only thing we'll need to do is, I think they may use the Elmo, so we may need to switch. We can maybe a short 5-minute break or something like that. I do have one quick question, Your Honor.
Sure.
The state law, you're going to read all the instructions first. If you don't read the last 4 or 5 instructions, can we still make reference to those?
Yeah, I have no problem with that. Unless somebody else has. I just think those last instructions are more directed to what they're going to do as opposed to giving them. It just seems to be better to do it that way. The instructions open. Okay. I'm going to get my computer because I can correct that. Members of the jury, statement of the charge. The trial information charges the defendant, John David Green, with the crime of murder in the first degree. The crime of murder in the first degree includes the lesser crimes of murder in the second degree, voluntary manslaughter, and involuntary manslaughter. The defendant has pled not guilty to all charges. Instruction number 1. The trial information is the document which formally charges the defendant with a crime and is merely the method by which the defendant is brought into court for trial. It is not evidence. Instruction number 2. The defendant has entered a plea of not guilty. The plea of not guilty is a complete denial of the charges and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 3. The defendant is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 4. You must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. You must consider all of the instructions together. No one instruction includes all of the applicable law. Instruction number 5. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 6. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 7. The burden is on the state to prove the defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence or lack of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act. Proof beyond reasonable doubt, therefore, must be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond reasonable doubt does not mean proof beyond all possible doubt. If after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt, and you should find the defendant guilty. But if after a full and fair consideration of all the evidence or lack of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt, and you should find the defendant not guilty. Instruction number 8. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 9. You shall base your verdict only upon the evidence and these instructions. Evidence is testimony in person or by deposition, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. Stipulations, which are agreements between the attorneys. Any other matter received into evidence. Sometimes, during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers, objections and ruling on objections, testimony I told you to disregard, anything you saw or heard about this case outside the courtroom. Statements and questions by law enforcement officers during an interview with the defendant are not evidence to be considered for their truth. The defendant's answers and responses to those questions and statements are evidence. Instruction number 10. Evidence has been offered to show that John David Green made statements at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence, just as if they had been made at this trial. You may also use these statements to help you to decide if, and that's a typo in there, and we'll get you a corrected page on that. If you believe John David Green, so that will read, you may also use these instructions to help you decide if you believe John David Green. You may disregard all or any part of the defendant's testimony if you find the statements were made and were inconsistent with the defendant's testimony given at trial, but you are not required to do so. Do not disregard John David Green's testimony if other evidence you believe supports it or you believe it for any other reason. Instruction number 11. In considering the evidence, you may make deductions and reach conclusions which reason and common sense lead you to make. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. You should not be concerned whether the evidence is direct or circumstantial. Direct evidence from a witness, direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show the defendant is guilty or not guilty. The law makes no distinctions between the direct evidence or circumstantial evidence. Give all evidence the weight and value you think it is entitled to receive. Instruction number 12. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. You must try to reconcile any conflicts in the evidence, but if you cannot, you will accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, whether the testimony is reasonable and consistent with other evidence you believe, whether a witness has made inconsistent statements, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 13. You have heard testimony from a person described as an expert. Persons who become experts in a field because of their education and experience may give their opinions on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all other evidence in the case. Instruction number 14. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that the person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to conclude a person intends the natural results of his acts. Instruction number 15. The state must prove all of the following elements of murder in the first degree. Number 1. On or about the 5th day of June 2009, the defendant strangled Mark Koster. Number 2. Mark Koster died as a result of strangulation. Number 3. The defendant acted with malice aforethought. Number 4. The defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Mark Koster. Number 5. The defendant was not justified. If the state has proved all of the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of second-degree murder explained in instruction number 21. Instruction number 16. The injury inflicted by defendant resulted in the death of Mark Koster if it caused or directly contributed to his death. Number 17. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Instruction number 18. Willful means intentional or by fixed design or purpose, and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Deliberation and premeditation need not exist for any particular length of time before the act. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 19. If a person has an opportunity to deliberate and uses a dangerous weapon against another resulting in death, you may, but are not required to, infer that the weapon was used with malice, malice aforethought, premeditation, and specific intent to kill. Instruction number 20. A dangerous weapon is any sort of instrument or device which is actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. Instruction number 21. The state must prove all of the following elements of murder in the second degree. On or about the 5th day of June 2009, the defendant strangled Mark Koster. Number 2, Mark Koster died as a result of strangulation. Number 3, the defendant acted with malice aforethought. Number 4, the defendant was not justified. If the state has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of voluntary manslaughter as explained in instruction number 23. Murder, instruction number 22. Murder in the second degree does not require specific intent to kill another person. Instruction number 23. The state must prove all of the following elements of voluntary manslaughter. Number 1, on or about the 5th day of June 2009, the defendant strangled Mark Koster. Number 2, Mark Koster died as a result of strangulation. Number 3, the strangling was done solely by the reason of sudden, violent, and irresistible passion resulting from serious provocation. Number 4, the defendant was not justified. If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of involuntary manslaughter as charged in instruction number 24. Instruction number 24. Concerning instruction number 23.
That is correct, Your Honor.
Again,
In instruction number 24?
now instruction number 23, the last number of 23 is read.
Oh, yes, that's correct.
Sorry about that, folks. We'll get you that corrected. Instruction number 24. Concerning element number 3 in instruction number 23, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his passion under control and suppress the intent to kill. Words alone, however, abusive or insulting, cannot be serious provocation. Instruction number 25. The state must prove all of the following elements of involuntary manslaughter. Number 1, on or about the 5th day of June 2009, the defendant recklessly strangled Mark Koster. Number 2, the defendant did act in a manner likely to cause death or serious injury. Number 3, by doing the act, the defendant unintentionally caused the death of Mark Koster. Number 4, the defendant was not justified. If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty. Instruction number 26. A person is reckless or acts recklessly when he willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences, and a person knows or should know a risk of harm to another is created. Though recklessness is willful, it is not intentional in the sense that harm is intended to result. Instruction number 27. The defendant claims he acted with justification. A person may use reasonable force to prevent injury to another, including the defendant. The use of this force is known as justification. Reasonable force is only the amount of force a reasonable person would find necessary to use under the circumstances to prevent death or injury. A person may use deadly force against another if it is reasonable to believe that such force is necessary to avoid injury or risk to one's life or safety, or the life or safety of another, or if it is reasonable to believe that such force is necessary to resist a like force or threat. Deadly force means force used to cause a serious injury. 2, force the defendant knows or should know will create a strong probability that serious injury will result. A serious injury is a bodily injury that creates a substantial risk of death or which causes extended loss or impairment of the function of any bodily part or organ. The term bodily injury means physical pain or any impairment of physical condition. The state must prove the defendant was not acting with justification. Instruction number 28. A person is justified in using reasonable force if he reasonably believes the force is necessary to defend himself against any imminent use of unlawful force. If the state has proved any one of the following elements, the defendant was not justified. Number one, the defendant started or continued the incident which resulted in injury or death. Number two, an alternative course of action was available to the defendant. Three, the defendant did not believe he was in imminent danger of death or injury, and the use of force was not necessary to save him. Number four, the defendant did not have reasonable grounds for the belief. Number five, the force used by the defendant was unreasonable. Instruction number 29. Where two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. Concerning instruction number 28, the defendant was not required to act with perfect judgment. However, he was required to act with the care and caution a reasonable person would have used under the circumstances which existed at that time. If, in the defendant's mind, the danger was actual, real, imminent, or unavoidable, even though it did not exist, that is sufficient if a reasonable person would have seen it in the same light. Instruction number 31. Concerning element number 3 in instruction 28, the defendant claims danger existed. You are to consider the danger or apparent danger from the viewpoint of a reasonable person under the circumstances which existed at that time. It is not necessary that there was actual danger, but the defendant must have acted in an honest and sincere belief that the danger actually existed. Apparent danger, with knowledge that no real danger existed, is no excuse for using force. Instruction number 32. Concerning element number 2 of instruction number 28, if a defendant is confronted with the use of unlawful force against him, he is required to avoid the confrontation by seeking an alternative course of action before he is justified in repelling the force used against him. However, there is an exception. If the defendant was in his own home, which he was legally occupying, and the alternative course of action was such that he reasonably believed he had to retreat or leave his position to avoid the confrontation, then he was not required to do so, and he could repel force with reasonable force, including deadly force. If the alternative course of action involved risk to his life or safety, and he reasonably believed that, then he was not required to take or use the alternative course of action to avoid the confrontation, and he could repel the force with reasonable force, including deadly force. Instruction number 33. No matter how insulting the words used by Mark Koster, they will not in and of themselves justify the use of force by the defendant. However, words of provocative and insulting nature may be considered together with all the other evidence to determine who started the incident and whether the defendant's apprehension of danger was reasonable. Instruction number 34. Evidence has been received concerning Mark Koster's character for being violent. This evidence bears on whether Mark Koster was the aggressor at the time the defendant strangled Mark Koster. Instruction number 35. I am giving you 5 verdict forms. You must use only one of the verdict forms. And now I'm going to ask you to turn over about 3 pages. And it has forms of verdict that upper right hand corner. Forms of verdict. Verdict form number 1. We, the jury, find the defendant, John David Green, guilty of the crime of murder in the first degree. And then there's a place for the foreman or forewoman to sign. He will sign, the person will sign there if that is your unanimous verdict. Verdict form number 2. We, the jury, find the defendant, John David Green, guilty of the crime of murder in the second degree. If that is the unanimous verdict of the jury, the foreman, your foreman or forewoman will sign that form of verdict. Form of verdict number 3. We, the jury, find the defendant, John David Green, guilty of the crime of voluntary manslaughter. If that is the unanimous verdict of the jury, your foreman or forewoman will sign that verdict form. Verdict form number 4. We, the jury, find the defendant, John David Green, guilty of the crime of involuntary manslaughter. If that is the unanimous verdict of the jury, your foreman or forewoman will sign that verdict form. Verdict form number 5. We, the jury, find the defendant, John David Green, not guilty. If that is the unanimous verdict of the jury, your foreman or forewoman will sign that verdict form. And now I'd ask that you lay those instructions aside because I want you to give full attention to the summations that the attorneys will now be presenting to you. As I previously indicated in this case, previously indicated to you in this case, the state will be going first, and then Ken will have an opportunity to make his closing argument, and after he has, the state gives his second opportunity to argue to you, and that's because, again, because of the burden of proof that's on the state. Mr. Hammer and Mr. Smith, I don't know who's going to do the fight. Okay?